We're going to expect a juror to do that? Let me bring in my think tank tonight. Joining the criminal defense attorney, Holly Waltman, and Joseph Marone, another great criminal defense attorney. She's in Atlanta. He's in Philadelphia. Holly, really? Really? Ordinary citizens who are doing their civic duty, part of their civic duty now is to tell these lawyers and R. Kelly whether or not they've ever had an STD?
So I actually had this conversation a few days ago. The first few rounds of juries that get selected to serve right after this COVID-19 pandemic are going to be some of the most challenging people because everybody is so anxious to get back to your own life and to your own career. But Vinnie, this is the only shot that they have at normalizing or striking up a conversation with a potential juror about something that's going to be very relevant to this case, but also very personal. So this is the only shot. And I think because we are in federal court for this case, we're going to see many different versions of this before we get the one that's approved by the judge to be sent out.
Joseph Marone, no, we cannot force people to talk about their STDs, whether they have them or don't have them, had them or didn't have them, if their wife has them, no, or their husband. No, we can't do that. That's outrageous.
Well, listen, you got to look at it this way. The defense lawyer is defending this man. He's fighting for his life. The most critical component to any criminal case is voir dire, questioning the jurors, trying to find out essential information, trying to get the best jurors on your panel to obviously clear your client. So in this case, a key issue is the transmission of a sexually transmitted disease. To get information to see if any juror was subject to that, listen, it's not just were they subject to that, how did they get it? When they received it, did they know about it? How did they feel about it? That's some critical information.
Wait a minute, Joseph. Wait, you want a detailed account of how they got the STD now?
No, I'm saying that's what's in a particular juror's mind. So now you need to get some information. If this is a critical piece of evidence in this case, right, the transmission of a sexual disease, right, if it defines this man's life right now, he needs to know what those jurors have been through. So he's entitled to ask questions. Whether the judge is going to let it happen is another question. I mean, clearly the state has objected, and I think there'll be some happy medium, but you need to know some information if that's part of this case.
And you can't put in the COVID problem right now. Holly Waltman, you either got it or you don't got it, Holly. That's the way it works.
Well, sure, that's the way that it may work. But in this case particular, and Vinnie, I want to point out, sometimes during these, I'm going to call it like a pre-trial, right? When you are getting ready to fight for someone's life, literally, this is what they're doing for R. Kelly here. You need to pre-try your case. And so if the state would maybe send back a proposed way to ask this question, it might actually reveal to the defense team something about the way that the state is going to present their chiefing case.
All right. Joseph Marone, how would you tactfully ask a complete stranger who probably doesn't even want to be at the courthouse because they probably don't want to miss more work because we're all missing, a lot of people are missing work already. But how are you tactfully going to ask someone if they, ever had herpes or syphilis or gonorrhea or chlamydia? How are you going to do that?
Well, the way the question's posed now is asking them whether they were ever exposed to any type of sexual disease. Obviously, the state has tried to kind of lessen the blow and try to ask it in a more subtle way to see if there were ever any instances whatsoever, whether there's been something like that in their life. But trying to get that information out is so critical to the case. And to hold the defense at fault for it is not the thing to do here. I think they're doing the right thing, and whether this judge allows it or not, I think they're going to allow some way into that topic because it's a critical component or a piece of evidence that's going to decide this R. Kelly's guilt or innocence.
Yeah, I don't think whether or not juror number 3 ever, all right, let's move on. I don't want to gross people out here. Bail is another issue. Let's go to another disease. Let's go to COVID-19 instead. And this is a basis for the defense trying to get R. Kelly out pre-trial. And some of the arguments are that there are at least 6 known and confirmed positive cases of COVID-19 amongst the population where Mr. Kelly, R. Kelly, is being detained. And not only is he on virtual lockdown, Mr. Kelly now gets 1 phone call per week, 1 per week, and his attorneys cannot visit him. I spoke to his attorney, Steve Greenberg, about this.
We have thousands and thousands of pages of discovery already that we've received on this case. We need to sit down with him. We need to read these materials to him because he can't read them to himself. He can't read, he can't write. We need to talk to him about these materials. Frankly, I'm not going to go in the jail, even if they told me I could go in the jail, because it's not a safe environment. You can't socially distance. If there's any hope of this case going to trial this year, he needs to get out.
All right. I'm not necessarily with Greenberg on the STD issue, but let's talk about this one. DeWitt Lacey also joins, a civil rights attorney, former criminal defense attorney, is in L.A. tonight. Great to see you, DeWitt. This, to me, is a real issue. If you're preparing for a trial, and I've read through the federal indictment in Brooklyn for this case, I don't know how you prepare for that trial with a client who cannot read or write without spending hours with him, and that's not happening now. So do you think there's any chance a judge might let him out so they can meet and can prepare for the trial that the judge wants to happen in September?
Well, I'll tell you, Vinny, I think it really depends upon whether or not the court determines that Mr. Kelly is a danger to the community at large. Yeah, sure. There are complications that every criminal defendant at this point right now are going to have in regards to continued in litigation. However, the considerations that the judge is going to have to make is what danger does it pose to allow R. Kelly or any criminal defendant for that matter to be released? And we're talking about incidents in this circumstance where there's minors involved. It's terrible allegations that have been made against them, but the implications of letting him out might prove to be more risky. I hate to say it, but it seems like the judge is probably going to go, rule against allowing R. Kelly to get out of jail.
All right, Holly, this is a challenge, and I'm not saying let R. Kelly out, but what I'm saying is, you're entitled to prepare for your trial, and that just seems to be impossible at this point. And they've set this date, September 29th. They're already working on the jury questionnaire.
Absolutely. And it's kind of a double-edged sword, right? One of the things that a defendant has to be able to do or should be able to do is assist their counsel in preparing for their defense. And that, of course, becomes virtually impossible if you have an illiterate defendant and now someone who you can't spend any extended period of time with in a jail. So in order to make sure that this case does go forward in September, R. Kelly has the resources for an ankle monitor that would have GPS locations. We could craft some sort of order that the judge could sign saying that he's under a curfew and he's not allowed to leave his house. He certainly has the resources to do it. I don't know that he will, because of course then it highlights that people with resources and the ability to have a legal team that writes multiple bond motions for you per week, you get a bond and they don't. So it is a double-edged sword here.
Yeah, well, he's not the only one who's getting out or potentially getting out because of COVID-19. We've seen thousands across the country. And coming up, we're going to talk about one of those cases out of Florida where someone with, I think it's 35 arrests in his history, is let out as a low-level offender and is now back in custody charged with murder. We'll talk about that when we come back.
The spread of coronavirus in prisons threatens the health and safety of all of us. When you're incarcerated, there's no such thing as social distancing, and ensuring good hygiene is not an option. Leaders must do everything possible to prevent incarcerated people and those who work in prisons from becoming ill and spreading the virus. I'm calling on Governor Andrew Cuomo to take action in New York by granting clemency to New Yorkers in prison. The lives of so many people depend on his action. No one deserves to die in prison from COVID-19.
There's a huge movement, and celebrities like Joaquin Phoenix are talking about this, about releasing inmates from prison, releasing inmates from jail, that just letting people out because you cannot do what we all are doing, locking down, social distancing while you're locked up. You just can't do it. But the question is, people are in prison and in jail generally for a reason, right? You're in prison because you're convicted of a crime and you can't follow the rules of society. So are we endangering the community and taking that safety for granted to a certain extent in light of all these inmates who are now being released? Well, inevitably, something bad is going to happen, and it appears that it did down in Tampa. One of the low-level offenders who was released is back in custody. Chanley Painter has more.
Initially, I was shocked. I was in disbelief.
Crime victims advocates are discouraged at the news that a Florida inmate shot and killed a man one day after he was released due to coronavirus concerns.
To hear that he murdered somebody just that quickly.
26-year-old Joseph Williams was one of the inmates from 2 county jails in Tampa, Florida, released March 19th.
We have taken an emergency measure to release from custody 164 inmates who were arrested for low-level, nonviolent crimes. These defendants are the lowest public safety risk and were merely sitting in jail because they could not afford to pay the amount it would take to bond out.
Across the U.S., thousands more have been released early from jails and prisons, all in an effort to curb the spread of COVID-19.
It is my hope that these individuals will make the most of this opportunity to be with their loved ones, help them prepare, comfort them, and quarantine with them.
But the Hillsborough County Sheriff says Williams took advantage of the health emergency to commit crimes. The day after he was released, he was arrested and charged with second-degree murder, resisting an officer with violence, and gun and drug charges. According to the sheriff's office, Williams has a lengthy criminal history. He had previously been arrested on 35 charges and has convictions for felony burglary and possession of a firearm.
That was one of the first things that I wondered was what determined his low-level criminal status.
While Williams is the only one of the 164 released to have been arrested again, the case could give rise to concerns for public safety over the health of individual inmates.
When situations like a coronavirus happen, that doesn't give a criminal a reprieve to be released.
The Hillsborough Sheriff has called for Williams to be prosecuted to the fullest extent of the law, but that is likely little comfort to those impacted by his actions.
You let a violent criminal out, and he killed someone faster than a coronavirus did. You know, at least if you have the coronavirus, you can get diagnosed, you can get treated. But this person who was murdered didn't have a chance.
Let's think about this for a second. You know, how are we defining low-level offenders? Is it just what they are locked up for on that charge? Or are we looking at their history? And I think that's what this case is all about. Are we really looking at individuals, or are we just looking at, okay, he's in on this, let him out? Let's bring back in our think tank. Joseph Marone, he's in on drug charges, paraphernalia, not the most serious, right? There's tons of those kinds of cases, but he's got a history of 35 arrests, so that's a little bit of a red flag. Convictions for burglary and possession of a firearm. Is this the kind of low-level offender we should be letting out?
Well, I think the state really dropped the ball on when the procedure they wanted to use to make the decision. Because just on its face, it was a possession charge. The bail was only $2,500. I mean, he could have posted the bail and got himself out anyway. But they just had a sheet long of prisoners that they could release. But they didn't do their due diligence and look at this fellow's background, which was really this was a bad dude. I mean, he had a lot of convictions, some serious stuff, and ultimately someone paid the price. So I think now this is ultimately a wake-up call, and unfortunately someone died, but they're going to have to really kind of tool the system. It's not just the crime itself that they're arrested for, because remember, he wasn't convicted. It's the background of the individual that's really got to play into it. Just because someone gets charged with a minor drug offense, if this person's got some serious criminal history, you can't let that person back out on the street. And that's what happened here, and it's unfortunate someone really paid the price for it.
Yeah, do it. I would take that $2,500 that he couldn't post and factor that into everything here. You've got someone who's perhaps got a drug problem, has had firearms before, can't even get his hands on $2,500, or doesn't have any friend or family member that would put the money up for him. and now you're going to let him out on the street. What do you think he's going to do? What do you think he's going to do?
Well, Vinny, I don't know that that's fair. Look, there are a lot of people in this country that don't necessarily have the money to post bond, even for something in our minds that might be deemed low in $2,500. So I'm not going to crucify him on not being able to post that bond himself or have a family member to do that. However, I do think there's a valid point in considering the past criminal record when you're going to release someone if they have not posted the bond. Though you shouldn't have to continuously pay for the sins that you've made in the past, in the circumstance where you might pose a violent threat to someone, I think that is fair to consider it. With that in mind, if I play devil's advocate here, Vinny, I will say this. This probably will be used as the poster child for why you cannot let people out due to the coronavirus. But there were, as if I understand it, 164 persons who were let out. One of them did commit a very heinous crime. Okay, one of them did. That's undoubted. But there are 163 others that may just be going about their lives and doing what they need to do in order to become more productive members of society, and that shouldn't be overlooked.
Or they haven't been caught. I mean, that's the other part of this, but I'll give them the benefit of the doubt tonight. Holly, here's my equation with the 2,500. What's that?
I said that's the prosecutor in you, Vinny.
Oh, absolutely, absolutely. And I'm safety first is my rule. But Holly, here's how I put the $2,500 in the equation. Not so much that we're going to crucify someone because they don't have the money, but someone who's got a drug problem and doesn't have the money is going to get the drugs. How do we think they're going to get the drugs? Are they going to get a loan from someone, or are they going to resort to crime to get it? That's my point, Holly.
Yeah, and I understand that, Vinny. And what I think failed here is that when judges across this country sit down to consider bond for an individual accused of a crime, there are four major things that they look at. And it's the comprehensive look at all of those things. One of those, namely, is likelihood to commit felonies if given the opportunity to post a bond. Had this individual and had all of those 180, however many there were, that they released, been looked at in a comprehensive way under those same four factors that we look at to determine someone's eligibility for bond to begin with, I doubt that this would have fallen through the cracks because someone would have looked at him and said exactly what you just said and echoed the same fears that this person will rob, steal, beg, borrow for drugs. And if that means putting a gun to someone and shooting them for them, he'll do it too.
All right, when we come back, we got another case we need to talk about. This one's out of Virginia. A whole community was looking for this beautiful little baby. His name was Noah. He was ultimately found, but he wasn't alive, and now his mom has been charged.
Welcome to Court TV Live, your front row seat to justice.
It's a busy day here at Court TV.
That is the game changer.
You have to look at everything in this case.
He murdered our daughter.
You take the hose and squeeze it.
Guilty on all counts.
This is true crime all the time.
We continue our gavel-to-gavel coverage,
And you're not going to miss a moment of it.
This is what I love to do.
Get emergency services to go and send police into another person's address because of a serious but false emergency. And the 19-year-old former college student was arrested back in January, accused of doing it to an African-American church and to his own university, Old Dominion in Norfolk. Both of those cases happening in 2018. The terms of his plea deal have not been disclosed at this time, but he does have a plea hearing that's set for May 8th. And the singer, R&B singer R. Kelly is asking for a new request to be released due to the coronavirus pandemic. He already had a motion that was denied last week from a judge who said that he didn't meet the criteria to be released because of COVID-19, saying he was not in an at-risk group. Now, the latest emergency motion that was filed today, Kelly's team claims that the singer should be released urgently now that there are 6 confirmed cases of COVID in the Chicago facility where he is detained. Now, the motion also insists that he is not a flight risk. Also today, at a status conference in Kelly's case, a federal judge in New York has scheduled the trial there for September 29th, and the trial for the federal charges that he faces in Chicago is scheduled for October 13th. Vinnie, he also has state charges in Chicago that he is facing, so no word yet on whether that trial is going to be continued in light of the other two that are now set.
All right, not a flight risk. This is a man who believes he can fly. Why are they arguing that he's not a flight risk here?
In that emergency motion, they say he is afraid to fly, that he does not have a passport, and that should be a reason that this court should understand that he's not going anywhere and that he's too famous to be walking around undetected. They promise he's going to stay at home.
Wow. So the man who believes he can fly is afraid to fly. That's the headline. Julia Janae, thank you for that. Thank you. Appreciate it. All right, folks, moving on to Virginia. And this is an absolutely tragic case. There's a beautiful little boy. Baby Noah is his name. Went missing, community search for him, and ultimately they found him and Noah was no longer alive. Julie Grant has more.
Well, everyone loved you.
Baby Noah Tomlin's sudden disappearance rocked the community of Hampton, Virginia.
They've checked under houses, they've checked in sheds, they've checked cars. I'm hoping they checked the trash cans. I'm hoping that's why it hasn't been picked up. They've had drones out here, they've had dogs out here.
The 2-year-old was living in the Bayside Mobile Home Village with his mother, Julia Tomlin, and 2 other siblings. The morning of June 24th, 2019, Tomlin reports baby Noah missing, and a massive search ensues.
We put so many different sets of eyes on the immediate search area.
Law enforcement and community members teaming up, searching for baby Noah.
So any scrap of clothing, any diapers, any evidence that may lead us in a particular direction, we want to take that into consideration.
At the Hampton landfill, city crews sift through 2 million pounds of garbage, hoping baby Noah could still be alive.
We feel very confident that we have exhausted all reasonable efforts and all reasonable resources in our search area.
Then on day 10, a grisly discovery. Baby Noah is found dead at the Hampton Steam Plant, the place where city waste goes to burn. His autopsy results revealing his skull was fractured in 2 places. The cause of death, blunt force trauma to the head with signs of battered child syndrome. The manner of death, homicide.
Everyone will always love you, and Jesus will take care of you.
Julia Tomlin told investigators her baby hit his head while in the bathtub unattended and drowned. But investigators found her story to be inconsistent with the horrific evidence in the case. Tomlin is charged with murder, unlawful disposal of a dead body, and child neglect. The 35-year-old undergoing a mental competency evaluation to determine if she's fit to stand trial.
And mental illness, an issue in this case, and absolutely tragic for that little boy. The one bit of good news that we did get, the other children are being taken care of by grandma and grandpa and apparently doing very well. So we're thankful for that. Let me bring back in my think tank. This is always, these types of cases are extremely difficult. There's always some level of mental illness usually involved in things like this, or drug use. Here, they're talking about competency, Holly, competency. And that's going to deal with what her mental state is now, right? Not at the time of Noah's death, but what's going on with her right now.
Right. And one thing that's really important for everyone who's watching to understand is that legal competency to stand trial is such a low threshold. It basically is just confirming that that person can understand simple thoughts and can participate and understand the proceedings around you. It really has nothing to do with her mental state then or the time that this happened, but rather, can she understand the proceedings going around? And absent something crazy happening, which this case is going to have a lot of twists and turns, she will likely be found competent.
Joseph Marone, let's talk about the other part of mental illness in criminal courtrooms, which is legal insanity. How How does that work, right? You're a criminal defense attorney and you've got a client and you've got to do everything for the client. You talk with the client. How do you have a conversation with them that, hey, you're insane? Like, how do you approach going for that type of defense with someone who you have to speak with and you've got to say, yeah, you're legally insane?
Well, it starts off by your own consultation with the client and trying to see if you can communicate and get information. If you think that's a possible defense, I mean, you're going to hire an expert who's going to do a full evaluation to make sure and see if there's a determination whether this specific defendant is incompetent to stand trial. It's a low standard, and if they understand, they read, write, and understand the English language, they understand what's going on, and various other variables, unless you provide an outside mental illness pre-existing, it's going to be very difficult to prove that this person is not competent to stand trial. And unless there's other pre-existing medical evidence that may be a history here, you're not going to get very far. It seems to be in this case, and this person was a really bad heroin addict, and it's evident from the evidence they already found, and I think that's where this thing's going to kind of bear out.
Yeah, I would agree.
I think so too.
Yeah, I mean, listen, this person was significantly on drugs. She was looking for heroin that night. Somebody came around and brought her heroin, and then ultimately whatever went wrong with the child and her story. But the bigger problem is when they eventually went back and did an autopsy. I mean, there was healing rib fractures, which tends to believe there was ongoing abuse. So this horrible mother was doing drugs constantly and abusing this child, if not others. So that's the way the evidence is going to kind of come out physically and through the medical evidence that's been determined so far.
Go ahead, DeWitt. You can jump in there.
Yeah, no, I kind of have a problem with the excuse that she gave initially, which was that she took her baby to bed at 1 a.m. and, woke up to find him injured and in the state that he was at 11. That doesn't even sound reasonable to me, personally. Not only I don't think did the law enforcement do their due diligence there, but she definitely got the benefit of the doubt when maybe she should not have. As far as the competency goes, I would have to agree with everybody else. I don't know that there's going to be any rightful or reasonable manner in which she can be determined to be less than competent to stand trial or have an insanity plea as a defense. I just don't see it happening.
And Holly, no way she can use drugs as a defense, right? You can't say in there, I didn't know what I was doing. I was on drugs.
Unless someone put her on those drugs, voluntary intoxication of any kind is not going to be a defense that's viable. It would have to be some sort of outlandish claim that someone else was drugging her and she didn't know. And I don't think that that's going to be supported by evidence. I think at this point, besides being a heartbreaking, gut-wrenching, factual case, I do think that this will be a very interesting forensic case. I mean, I know they already called in I think it was a paleontologist to come in and recover the remains of the baby. So it will be a very technical case, and I think that could lend itself to a certain type of juror that you would want on your jury.
Yeah, the other thing, Vince, is I think ultimately in this case, she's going to end up pleading. It's a question of whether or not you can get a lesser charge on murder, and they're going to look to mitigate it out with the heroin addiction, the long-standing drug addiction. She's getting rehabilitation. She's dealing with it to try to save her some time because she's probably looking at a life sentence. And her defense lawyer is going to try to do everything he can to try to minimize that. And I think that's the best you're going to get in this horrible case. And there's going to probably be a stay away order from all her children. She doesn't deserve to see any of her children probably for the rest of her life. And that's ultimately what's going to happen.
Yeah. And again, the good news there is Grandma and Grandpa doing a wonderful job. And they say the kids are doing well. When we come back, there's a stay-at-home order across the country in all these states. One of the states where there's a stay-at-home order, someone decided, I'm going to have a Corona block party and I'm going to live stream it. Well, he got arrested, dragged into court, but the judge threw out those charges related to the stay-at-home order violation. What do you think about it? 13th juror speaks out next.
He's going to be charged everybody should be charged. It really constituted selective enforcement of the law. There were other individuals in our community that had committed the same criminal conduct, yet they were not charged. 30 white individuals that were gathered protesting Governor DeWine's press conference, and they were outside. They were violating the 6 feet distance rule. Some of them were armed, participating in violent rhetoric and banter. There was no charge against those individuals.
That video out of Cincinnati, Ohio, in the Over the Rhine neighborhood. Apparently, someone wanted to throw a Corona block party and violate the stay-at-home orders. Well, police jumped in, and as you saw, arrested and charged that young man. The judge ended up throwing that charge out, throwing the stay-at-home violation charge out the door. So, posted it today. Your reaction of the 13th juror. Let's get right to our comment of the day from April, who says, sorry, but calling them orders indicates it's law. That is completely unconstitutional and should never be upheld to such an extent. People willingly coming together should never be an issue. Now, if they were out perpetuating their presence to others that they were unwilling, I can maybe see citations, but arrests? Heck no! All right, DeWitt, your thoughts here. Are we in unconstitutional grounds now where we are just issuing orders that people need to stay home?
Well, I think it does step into your First Amendment rights and freedom of assembly. And, municipalities have to be cautious of that with these orders and the enforcement mechanism that they put in place to enforce them. I think that I think her name is April. I think was her name April?
April, absolutely.
April, I think April is right in saying that, look, people have a constitutional right to get together. Of course, that is certainly irresponsible, but the law doesn't demand that we act completely responsibly, and it cannot infringe upon somebody's right to gather. Now, certainly there are some public interest in making sure that the virus doesn't spread, but so long as these folks are not inciting violence, as was indicated by this fella, then I don't see how you really enforce it. The problem here is that they said that he was inciting violence, which is not protected.
Yeah, those are the other charges. Yeah, those are the other charges,
right.
But with the stay at home, that was thrown out. Kathleen writing tonight, yes, I agree with the judge. The man was only live streaming and not breaking the law. I agree with this attorney. No white protesters were arrested who were not following the 6 feet apart rule, and some of them were armed. Why should this young man be singled out? How about that, Holly? Do you have to arrest everyone who's violating an order in order for that order to be upheld?
So, of course not. You don't have to arrest everybody. It's obviously officers' discretion on who to arrest, who not to arrest. This individual, while exercising horrible judgment by inviting everyone to his house, didn't force anyone to come over. And so, in a way, how is he more responsible than the people that voluntarily came over there? The problem that I have, and the reason that if I was the judge and I was going to be deciding this case, what am I going to do with this individual? If he won't comply, am I going to lock him up in custody and for the next 14 days risk the health of the inmates that are begging and filing motion after motion for bond consideration? And so in a way, incarcerating him or keeping him in custody could prove out to be a more dangerous thing to do.
Not even more dangerous.
Stacey writes,
if I can, Vinny, if I want to piggyback on that, not even more dangerous, but that's violative of his constitutional rights. He can go out if he wants to. Of course, there's an order that suggests that
Vince, do you know what happened here? This guy live streamed a video, which he wanted to get attention. It got picked up by, I think, some hip hop publication. He says, we don't give an F about Corona. Now, the local law enforcement is trying to keep order on a virus that has nothing to do with race. It infects everyone. It's a dangerous, as soon as you get next to someone, it could spread and kill someone. So in order to get a hold of this situation, they have to go out, they arrest this guy for what he did to show the public that you can't take these actions and how dangerous it is. That's what he did. He incited violence. I mean, he enticed violence here. He live streamed and said, we don't give an F about Corona, and he's going to coerce other people to go along with him. I mean, that's a dangerous situation. That's what this thing was about. It had nothing to do with First Amendment rights and the ability to protest. What was he protesting? He was creating danger. So that's what happened here.
I respectfully disagree. He's got a constitutional right to assemble. That's in the Constitution. I understand the orders in regards to. I understand the orders in regards to safety. Okay, I get that, but they cannot infringe upon a citizen's right to assembly. All right, that's in the First Amendment, and the framers of the Constitution made it the First Amendment for a reason.
Yeah, but just because you assemble, you then can't take them to another step and go out there and entice violence. In this case, when you say go F Corona, you're telling other people, don't worry about the quarantine. Go out there, coerce in public and pass this deadly disease on to other people. And that's basically what he was doing. Now, if they allow this to continue to happen in the public, they're going to have an outcry. It's bad enough they can't control and get people to stay home. So if they don't make an example to the public, I mean, they're going to have a bigger problem. And that's what happened here. You can't start weaving the First Amendment into this. That's crazy.
Well, that is, the First Amendment is what it is. I don't think I have to weave it. However, look, I don't fault law enforcement for taking action and arresting, okay? But I think the court made the right decision in throwing out the charge because the person was exercising his First Amendment rights. And
but that was a misdemeanor. He's still charged with a felony. He's still charged with a felony. He's looking at 2 years now.
Hold on. And I will add, the selective way to enforce this upon a person of color instead of everybody else who may not have been a person of color and who are also armed is very concerning for me. And it should be concerning for all of us.
Next comment comes from Stacy. I just feel like having a Corona block party is just so flat out selfish, and it's unfair to all the people who are staying in and doing the right thing to save lives. We all want to go out and have fun. Do I think he should go to jail? No, but he should get a fine. I want to go to one more statement here. Joe, prosecute for what charge? What actual law was broken? Thank you, Joe. And thank you to DeWitt, Holly, and Joseph. I appreciate your time and your expertise tonight. Please come back and join us again. That is it for tonight, folks. We're here every night from 8 to 11, bringing you the world of crime and justice. I don't care if they're not having jury trials. We'll have trials right here every night. Have a wonderful evening. And as always, from a distance, don't forget, hug the kids.